Hey guys, welcome to my legal classes. This is Ganesh Pujari, and while discussing the regional human rights systems, there are five important systems. They are the European, American, African, Arabian and Asian regional human rights system. When it comes to the European regional human rights system, we have to focus on two important aspects. The first being European Commission of Human Rights, which started in the year 1953 and was there till 1998. And then the European Court of Human Rights, which got established in the year 1959. Why to waste time? Let's get into the first slide. Let us start the discussion by understanding the background of this entire convention. The Congress of Europe has established a Council of Europe, and the Congress of Europe had as many as 47 member states. And how are the member states selected? They are all of having same like-mindedness. They had the common heritage of political traditions. They had common ideals like freedom, etc. And the rule of law, stressing the maintenance and promotion of human rights, was available and had objective of unity among European countries. On the basis of that, a Congress of Europe has been established, under which a Council of Europe has been established. The Council of Europe, which is established by the Congress of Europe, organized the European Convention on Human Rights during 1950. Now, the important factor that you need to remember is this was originally proposed by Winston Churchill, and most part of the drafting of the European Convention on Human Rights was done by British lawyers, and this had a very high influence from the United Nations Universal Declaration of Human Rights, which happened in the year 1948. This was signed in the year 1950 in Rome and came into effect during 1953. One of the most important articles as far as the European Convention on Human Rights is concerned is the Article 19, which discusses about two important bodies, that is European Commission of Human Rights, herein after referred as the Commission, and a European Court of Human Rights, herein after referred as to the Court. So the Commission and the Court are the two important bodies which were being formed under Article 19 of the European Convention on Human Rights 1950. Before discussing anything about the Commission or the Court, let us try understand the rights and the protocols under this particular convention. Rights were there from the beginning of the convention, whereas protocols were added later, and there were about 14 protocols added till the year 2008. First, let us focus on the rights. Article 1 to Article 18 are discussing about 18 important rights from this particular convention. They are obligation to respect human rights, right to life, prohibition of torture and cruel, inhuman and degrading treatment, prohibition of slavery and forced labor, right to liberty and security, right to fair trial, no punishment without law, right to respect privacy and family life, freedom of thought, conscience and religion, freedom of expression, freedom of assembly and association, right to marry, right to an effective remedy, prohibition of discrimination, derogation in time of emergency, restriction on political activity of non-nationals, prohibition of abuse of rights, and limitation on use of restriction of rights. Then comes the protocols. I have few important protocols listed here. Protocol 1 on right to protection of property, education and free election. Then freedom of imprisonment for debts, restriction on entry to own country, etc. Death penalty during times of war was the Protocol 6, and Protocol 9 on individual application to the European Court in certain cases. So Protocol 9 is important because it gave certain amount of opportunity to the individual application to the European Court. But then comes the Protocol 11, which is one of the most important protocol, which will be discussed in my future slides also, which removed the Commission completely and then gave opportunity to the individuals to directly approach the court. That way Protocol 11 is very important protocol. Then comes the Protocol 12, which discusses about prohibition on discrimination, and then the Protocol 13, the total abolition of death penalty. And these are the few important protocols as far as this particular convention is concerned. Now let us shift our discussion to the two important bodies that were being created under Article 19, the Commission and the Court. Now the European Commission of Human Rights was created during the year 1953, and it is a history now. You heard me right. The European Commission of Human Rights was there from 1953 to 1998, and as of today, the European Commission of Human Rights is no more because of Protocol 11. So if it was there between 1953 to 1998, what was the role of the Commission? Remember, during 1953 to 1998, individual did not have direct access to the European Court of Human Rights, and the Commission was playing the role of scrutinizing the cases and then sending to the court. That means if you want to put a case in the court, first you should approach the Commission. Only after getting scrutinized by the Commission, your case would reach the court. That was the way it was done from 1953 to 1998. The problem was this process of scrutinizing was not easy. First, the individual will apply to the Commission, then the Commission will understand what happened in the case, then the Commission will decide whether it is important enough to go to the court, then it will also try for some friendly arrangement between the parties, then it will also check whether there are any personal rights are being violated. If everything is satisfied, then only the Commission would have referred the case to the court. So it was a cumbersome, like it had lot of difficulties to the individuals to reach the court itself. Now the entire convention is focused on human rights, but to reach the court itself there were a lot of difficulties. So by bringing Protocol 11, the convention decided to remove the Commission itself. So in the year 1998, they abolished the Commission and then gave power to the court and gave an opportunity to the individuals to directly take their case to the court itself. That was the end of the Commission, and now let us focus on the European Court of Human Rights. This came into existence in the year 1959 and today it is in Strasbourg, France. Before Protocol 11, as I have already told, cases were referred only by commissions, but after Protocol 11, the people got the right to directly approach the court. Now, how many judges are there? It is equal to the number of the contracting states, and as of today, that is 47. And no state will have dual judges. That means one state can have only one judge. That is one of the important rule. So if the European Convention on Human Rights has 47 members, the number of judges are also 47. For consideration of each case brought before it, the court consisted of a chamber composed of 7 judges, which is known as Chamber of Judges. What is the term of a judge? It is 9 years and it is a non-renewable time period. That means one person can enjoy this particular judge role only for 9 years and he cannot opt again. That is very, very important. It can be either 9 years or 70 years of his age, whichever is earlier. That is very, very important, and judgments are decided based on simple majority. This court has 2 important roles to play. One, hearing the application maybe by the individuals or the states, and then also give the advisory opinion. These are the 2 major roles of this particular court. And who can submit application to this particular court? It can be by an individual who should be national of these 47 countries, whichever I have referred earlier, and it may be a group of individuals of those 47 states or one or more of the other contracting states. These are the different parties who can approach the European Court of Human Rights. Now let us discuss 2 important case laws. The first being Lawless versus Ireland. Now, who was Lawless? Lawless was a suspected member of an illegal organization who was being arrested and detained by the Ireland government without trial under the Offence Act 1940. Now, he was suspected under an illegal organization, and then the important part is he was arrested and detained by the Ireland government without trial. That without trial is very, very important under the Offence Act 1940. Now, what does Lawless do? Lawless put a habeas corpus case which went on vain. Nobody gives any importance to that. The Ireland government doesn't hear him, but then he appeals to the ECTHR, that is European Court of Human Rights, and it held that detention without trial is violation of the convention and hence awarded compensation to Mr. Lawless. Now, what is important there? They have arrested and detained him without trial. So that without trial is violation of human rights under this particular convention. So he got the compensation. Remember that this case, that is the Lawless versus Ireland case, was the first case to be decided in this particular court. The second case that I am discussing is Iverson versus Norway. Iverson was a dentist who was practicing in Norway, and one fine day he gets an order from the Ministry of Social Affairs saying that he need to go and work in a remote village. Now Iverson was not happy. However, he goes to that village, reports to his duty, and after few days he quits the job. Now courts put some fine on him for the disobedience of the order of the rural service. Now Norway court put some fine to him. What does Iverson do? He approaches the European Commission of Human Rights. However, the Commission rejected the same, saying that the order from the Ministry of Social Service doesn't constitute forced labor. Iverson tried to prove that it was forced labor. However, the Commission rejected the same. If you want to refer more case laws, you can refer the Sunday Times versus United Kingdom and also Brogan versus United Kingdom. With that, I am concluding this particular class. I hope you got sufficient materials including case laws as far as the European system of human rights is concerned. With that, I am taking off from this particular class. Please subscribe my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.